Welcome everyone to the Life at AILA webinar, Acting Efficiently, Honestly and Fairly in an Octopus's Garden. I'd like to lead an acknowledgement to the traditional custodians of the land on which we work and live today and recognise their continuing connection to land, water and community. We pay our respects to their elders, past, present and emerging, and we extend that respect to any Aboriginal and Torres Strait Islander people here today. You've all joined the webinar in listen-only mode, which means you're muted. You can still participate though, and we encourage you to do that by clicking on the question mark icon on your control panel to ask questions. I will ask those questions, relay them to our speakers at the end of the webinar. The webinar will be recorded and a link will be emailed out on the day after the webinar for viewing for 2 days, and then you can access it down the track on the AILA library on our website. We're very lucky to have with us today two accomplished practitioners. We have joining us Laina Chan. Laina is a barrister at the New South Wales Bar, specialising in property, construction and professional indemnity. Laina also holds a Certificate of Management Excellence in Negotiation Strategy and Leadership from Harvard Business School and qualifications in International Commercial Arbitration from the International Chamber of Commerce in Paris. Excuse me. Laina is well known for striving to achieve the optimal resolutions for disputes using legal, commercial and strategic skills. Our other speaker this morning is Pamela McAlister. Pam is a principal with FM Super Resolutions and is an experienced financial services lawyer and governance specialist with particular expertise in superannuation law and practice, trust law, regulation and dispute resolution. Pam is an AFCA panel member. She was also previously a part-time member of the Superannuation Complaints Tribunal and the inaugural Superannuation Ombudsman for AFCA, where she helped to develop its superannuation jurisdiction as a successor to the SCT. Pam has also chaired the Superannuation Committee of the Law Council of Australia, being General Editor of the Australian Superannuation Law Bulletin, and lectured in superannuation, trusts and administrative law for several tertiary institutions. It would be hard to have more qualified speakers joining us today. The obligation for financial services licensees to provide the financial services efficiently, honestly and fairly has been described as overarching and fundamental. Since 2019, a breach of that obligation could give rise to stiff penalties, and there has been increased scrutiny and enforcement activity around this obligation. It therefore has significant importance for AFS licensees. If you were to review the lyrics to Ringo Starr's Octopus's Garden, you'd think it was somewhere safe and secure and without threat. However, if you've watched Octopus Teacher, you'd know that an octopus is smart. It can squeeze into any tight space and there's nowhere to hide from an octopus. So is the landscape for AFS licensees the idyllic garden of the Beatles' imagination, or more likely are the long and numerous arms of ASIC ready to grab onto any breach of that duty? Pam and Laina, I'm sure that you will be able to enlighten us today. Laina will be our first speaker and she will review the efficient, honest and fair obligation, and then we will have Pam. She will look at some of the recent case developments in this area, and then we'll move back to Laina to discuss fairness obligations for insurers and regulatory implications. I hope I've got that right, ladies. And now over to you, Laina.
Thanks, Melanie. That's the most poetic introduction I've ever had. I'd like to thank AILA and actually Stan Drummond for facilitating this opportunity to speak with you today. I'm just going to lay the background just for a couple of minutes before I pass it over to Pam to take over and discuss in detail what the cases have said about what the EHF obligations entail. But just by way of background, we all know that the insurance policy is a financial product, and that comes from definitions in the ASIC Act and in the Corporations Act. The slides provide the details of that. And as a result, insurers and brokers, as providers of a financial service in relation to a financial product, must be licensed. And in that way, the obligations of financial services licensees are imposed upon insurers and brokers. Now we have two sets of obligations. We have the core obligations that are set out in Section 912 capital A of the Corporations Act, and subsection 1A is the obligation to act efficiently, honestly, and fairly. Subsection B is basically to ensure that the licensee has in place arrangements to best manage the interests of the clients. Now, I think in the cases that Pam is going to be looking at, what appears to really upset ASIC is when financial services licensees prefer their own interests to the interests of the clients. And then we have in Section 912 capital B, the general obligations of financial services licensees. Now, as I've already said, the core obligation that we're focusing on today is the obligation to act efficiently, honestly, and fairly. I'm just going to pass over to Pam now for her to deal with the cases that have dealt with this issue in recent times. You're on mute, Pam.
Sorry, I just realized I was on mute. Thanks, Laina. So basically, I'm going to deal with the cases and Laina is going to then talk about what some of those practical obligations might be for insurers. You'll see that my slides have a bit of detail on them. That's not because I'm going to read the detail out, it's because I think you might like to read more later on and reflect on it after today's seminar. So just before I actually deal with the cases, I just wanted to give some background to this efficient, honest, and fair obligation, which is said to be a normative standard of commercial morality. Basically, before we had uniform corporations law, when we had state-based corporations law, the efficient, honest, and fair obligation was actually a ground for the Commission to take away a securities dealings license. So it was very much a licensing concept. And in that context, it was held to be a compendious concept, that is, intertwined rather than separate obligations. And the reason for that was stated in Story and National Company and Securities Commission, where the judge there said that in his view, a licensee couldn't comply with all aspects simultaneously, so it had to be a compendious obligation. And he also took reference to the fact that it says efficient, honest, and fair, rather than efficient, honest, or fair. Then when we had AFS licensing coming into effect in the early 2000s, it became a positive obligation of AFS licensees, as Laina has pointed out, so that in providing the financial services covered by your license, you need to ensure that you provide those services honestly, efficiently, and fairly. I just wanted to pause there for one moment, because what this obligation relates to is the provision of financial services. So you have to find a financial service covered by your license, which you have to then ensure is provided honestly, efficiently, and fairly. It's not just some overarching free-flowing obligation to do everything that you do efficiently, honestly, and fairly, although we'll see that that is sometimes creeps into the way the judges talk about it. So the first case that considered the obligation under AFS licensing was the ASIC and Camelot derivatives case, and I've given the citation there on the slide. And that case confirmed that it was a compendious concept. And subsequent cases listed also there have also confirmed that it's a compendious concept. And in particular, that last case, the Beach case, by Westpac Banking Corporation, Justice Beach elaborated what he thought that meant. He said that the efficient, honest, and fair obligation is a single composite concept rather than three discrete behavioral norms. And you'll see that the way he's interpreted them, when we read this quote carefully, is that they all intersect with one another. So each individual concept affects how we interpret the others. And he went on to talk about the fact that it encompasses competency, it encompasses adequacy of performance, but it also encompasses that element of commercial morality. So looking now to the recent law, I'm going to talk about that, what I call that Westpac security trilogy of cases. And I should add that, so this case was appealed all the way to the High Court, and it's now come back for its penalty. And the penalty, Laina let me know yesterday, has been now awarded, and it was $10.5 billion. So it was a significant penalty that was imposed, but importantly, not in relation to the breach of the efficient, honest, and fair obligation, because that wasn't a civil penalty at the time. The penalty is actually imposed in relation to the provision of personal advice without a license. So briefly, what are the facts? It's a superannuation case. Essentially, there was a marketing campaign by BT to get members to roll over their other superannuation into their BT account. And there were a number of steps in this marketing campaign. First, members were sent a letter where there was an offer to search for any other superannuation accounts they might hold, and that was followed up by a phone call from a team member or advisor who gave a general advice warning. The advisor said, "I'm calling to help you, and what do you think the main benefits would be of consolidating your super?" And then when the member answered, the advisor would confirm that member's reasoning by saying something like, "Oh yeah, that's what a lot of our members tell us," or "Oh yes, that's a very common response," which is known as social proofing language in order to, I guess, bolster the member's belief. And there was then an offer to implement the consolidation of their super on their behalf. The calls had what was called in the cases a QM framework, and part of that QM framework was designed to stop the advisors from giving personal advice, from straying into personal advice. So the framework was partly compliance-based, but it also had that marketing aspect to it, because part of the framework was to finish the call by getting the member to make a decision on the spot to roll over their lost super into the BT account. So in that circumstance, there was probably pretty little controversy that the advisors had actually given general advice. There was some brief discussion about that in the case, but you know, it was mostly accepted that because the whole purpose of the call was to influence the member, it was at least general advice. But ASIC said it went further, and that they had given personal advice in the calls because the advisors were eliciting some part of the member's objectives, financial situation, or needs in the calls, and either actively considered that information or a reasonable person might have expected them to do so. ASIC also said that ASIC breached the efficient, honest, and fair obligation because of the way it used that social proofing language to convince members to roll over their super. Westpac, on the other hand, said, no, we didn't give any personal advice because we didn't in fact consider the member's objectives, financial needs, or circumstances, and a reasonable person wouldn't have expected us to do it, given the nature of the call, and that we had an obvious self-interest. Please excuse the dog barking in the background. So at first instance, sorry about that. At first instance, Justice Gleeson found that no personal advice had been given, but she did think the efficient, honest, and fair obligation had been breached because she noted that the whole framework for the call was designed to convey the impression that to roll over your super was completely uncontroversial. She treated the obligation, consistent with Camelot derivatives, as a compendious one. On appeal, however, the full federal court found that personal advice had been given, and all of the judges confirmed that the efficient, honest, and fair obligation had in fact been breached, but expressed reservations about whether in fact it was a compendious obligation. Chief Justice Alsop reserved for another day whether it was a single composite concept or 3 discrete behavioral norms, and Justice O'Brien expressed considerable reservation. Now, when the matter went to appeal, the efficient, honest, and fair obligation wasn't discussed. Only the personal advice question was discussed. So in that sense, these views accepted by the full federal court haven't been tested in a higher court. I want to just look a little bit more about what these judges said, because what it indicates to me is an elevation, if you like, of the fairness aspect of the efficient, honest, and fair obligation over and above some of the other elements, particularly in this context. So Chief Justice Alsop said, if a body of deliberate and carefully planned conduct can be characterized as unfair, even if not dishonest, that might be sufficient for efficient and honest and fair to be breached. I think that's interesting. So he's honing in there on that unfairness aspect. He then goes on to talk about whether, if you do have unfairness, do you need any other ethical failing? And he, again, reserves his view about that. And then he finally says that this whole provision is part of the statute's legislative policy to require social and commercial norms or standards to be adhered to. He goes further. He talks again about fair and what does it mean? And then he gives an example. It could hardly be seen to be fair to set out for one's own interests, and this is the point that Laina was making earlier, to set out for one's own interests to seek to influence a customer to make a decision when prudently that should only have been made with personal advice. So there's almost an element of fiduciary duty creeping into this idea that you have to elevate someone else's interests above your own. And he then referred to the QM framework as being calculated sharpness. O'Brien had a similar view, but he firstly said, I don't see why a licensee couldn't comply with all three obligations simultaneously, even if they were discrete concepts. And he then went on to talk about what he thought each of the discrete concepts could mean. Efficient might mean competent. Honest might mean something more than dishonest in the criminal sense. It might mean, failure to act in a moral sense. And then fair, he thought, should just carry its own individual meaning of absence of injustice, even-handedness, and reasonableness. So he thought the three concepts could exist independently of one another. He said, I don't think they're inherently in conflict with one another, and therefore they could be imposed concurrently. And on fair, again, he honed in on fairness and said that the way the calls were conducted wasn't fair. Why? Because he said there was an asymmetry of knowledge. Westpac took unfair advantage of the asymmetry by implementing a carefully crafted telephone campaign. He was also influenced by the fact that because it was a superannuation context, there was an existing relationship of trust with the members. He was also influenced by the fact that Westpac didn't suggest to members that they get their own advice or reflect before making a decision. And then here's this language again. Rather, it acted in its own self-interest, which can be rightly described as unfair. So again, almost a fiduciary notion creeping in. Let's now turn to ASIC and AGM markets. Now, this is a very sad case, actually. This is a case where AGM offered over-the-counter derivatives to retail investors through an online platform and also by providing advice through telephone and email. They outsourced the provision of the advice to overseas call center representatives, and those representatives were remunerated through a share of profit. ASIC alleged that those representatives provided unauthorized personal advice. In fact, they didn't even give a general advice warning, and that they encouraged investors to make further trading deposits and adopt trading positions after eliciting personal information. And in fact, in some cases, when the investors said they couldn't afford to make any more trades, they had no further financial resources, the representatives still kept encouraging them to make one more trade in the hope of making the next profit. ASIC also alleged that they made false and misleading statements about risk, about profit, about revenue, and a lot of other matters. And in fact, in some cases, the representatives persuaded the investors to give control over their mouse, over their computer, so that the representatives themselves could make the trading positions. So not surprisingly, ASIC alleged breach of statutory duties to act in the client's best interests, give appropriate advice, unconscionable conduct, and of course, breach of the efficient, honest, and fair obligation. So you see in this situation, there is quite a bit of egregious conduct. And so therefore, not surprisingly, Justice Beach found that all of ASIC's allegations were made out, and he declared that appropriately. But he reverted back to his judgment in the Westpac banking case that I referred to at the very beginning. And he affirmed that in his view, it was a compendious intersective type obligation. And he repeated exactly what he said in the Westpac banking case about what the different elements might mean. And it was then brought to his attention that, in fact, there had been this judgment by the full federal court in the Westpac securities case. And he said, well, I don't think the full federal court should be followed on this point. And he gave a few reasons for that. Firstly, he said that in the case before the full federal court, both ASIC and Westpac had assumed that efficient, honest, and fair was a compendious obligation because they had assumed that the principles in the Camelot derivatives case applied. So therefore, it wasn't argued before the full federal court about how the expression should be interpreted. And similarly, in the appeal, the same assumption was made. He also found that because the majority hadn't actually given a ruling about how to interpret efficient, honest, and fair, he was bound by the lower court judgment in Camelot derivatives unless he considered it to be plainly wrong, which he did not. He also then sought to pare back what Chief Justice Alsop had said. And he said, while he agrees that the efficient, honest, and fair phrase isn't comprehensive, he wouldn't go so far as to say that it requires certain social and commercial norms, which of course was something that came out of the Hayne Royal Commission, this idea of community expectations and social and commercial norms. On the aspect of fair itself, he really made it clear that he would not be prepared to elevate fairness above the other elements of the obligation. And that was partly because he said it can't be defined except circularly. So what do you say? Fair means equitable, equitable means fair, and you go around in a circle. He said it's difficult to define it by reference to positive content, that is what you must do. And he made this comment. He said, it's not a backdoor best interests obligation. When you interpret the obligation, you have to look at the interests of both parties. And in coming to that view, he noted that it was a licensee disciplinary command. And therefore, as a standard, it should be suitably vague and flexible, and it should relate to the licensee's behavior as a whole in a general sense, rather than with regard to any one individual, because damages don't sound for an individual. And that meant, in his view, that no one word in the expression should be elevated, and he used this word applied asymmetrically in favor of an investor. So you can see there that he's paring right back the suggestions that came out of the full federal court judgment in Westpac Securities. I now move to the ASIC and Moby Super case. Now, I should add that this case was a case where the breach was admitted. So there isn't as much discussion about the interpretation of efficient, honest, and fair in this case. But briefly, the facts are that the trustee and Moby Super Tidwell was the trustee, and Moby Super was the promoter of a fund called Moby Super, which was part of a broader master plan. Under the promoter agreement, the marketing of the fund was outsourced to Moby Super, and the way Moby Super marketed the fund was by advertising a lost super search on its website. And then when someone clicked on and entered their details into the search, that would be followed up by a telephone call, shades of Westpac Securities here, from a customer service operator who would phone people and who entered their contact details, and often offer to open an account with the lost super money that was found for them. And then depending on what the person's personal circumstances were, they might also offer to add insurance into the account. So ASIC alleged that Moby Super provided unauthorized personal advice and made false and misleading representations. And I should add that those allegations are ongoing. The admissions only took place by Tidswell in relation to its role as trustee. So we don't want to make any comment about, the substance of those allegations because it's currently before a court. But in relation to Tidswell, ASIC alleged that it had breached the efficient, honest, and fair obligation in relation to the issue of interest in the Moby Super Fund. So here we've clearly got it tied to a financial service, the issue of interests, by failing to adequately supervise its representatives to avoid the risk. The judge was very careful to use that word, to avoid the risk of unauthorized personal advice or false and misleading statements being made. Tidswell, as I say, admitted to that breach. So in the course of making his judgment, Mr. Justice Jackson said, my role here is to express the court's disapproval of the contravening conduct, but I do need to be satisfied that there's a genuine case to answer. So therefore, he did look at the efficient, honest, and fair obligation to some extent. He noted the different views that had been expressed about whether it was compendious or whether it was three discrete behavioral norms. And he said, I don't have to decide that. Whichever it is, I think that the issue of interests was a breach of the efficient, honest, and fair obligation because there was this risk that the customer service officers would create an impression that rolling over your lost super to open a Moby account was just a matter of fact sort of thing. But he then did go on to cite, with approval, the Chief Justice's remarks from the Westpac Securities case. And he said, his Honor's words do capture the essence of the lack of honesty, fairness, and sound ethical dealing. So again, elevating those aspects which would have occurred in the present case if the risks had come to pass. I wanted to just very, very briefly cover two other cases where there have been admissions of the efficient, honest, and fair obligation. And the reason I wanted to mention these cases is because there isn't a readily identifiable financial service that was apparent from reading the judgments. As I said, they were penalty cases only. The breaches were admitted. They both related to the deduction of advice fees from a member's account, which in and of itself doesn't seem to be a dealing in a financial product, given that dealing is issuing, varying, disposing. It didn't appear necessarily to be a financial service there. And remembering that at that time, we didn't have the general financial service of operating a superannuation trustee service. So I can't readily identify what the financial service is for these cases, but I wanted to point out that in particular, the most recent one, which was just this year against BT and Asgard, in that case, fees were deducted even though a customer had requested the removal of the advisor, because the system had a coding error, and the coding error couldn't pick up that the advisor had been removed. So that's how that came about, and Asgard admitted that breach. In the earlier cases, they also related to fees. And in that case, there was also additional breaches relating to a defective PDS. So the efficient, honest, and fair breach was added on, if you like, because there had been a breach of some other financial services law. There is one further case that came out just the other day, and Laina is going to talk about this a bit more. It was a breach of the efficient, honest, and fair obligation through a failure to supervise representatives, so a bit like the Moby Super one. Mashinsky J was the judge in that case, and he didn't say much about this dichotomy between how we interpret the efficient, honest, and fair obligation. He just thought it was a broad concept and that it wasn't limited to conduct that was morally wrong. So we don't really have a settled view. So what does that mean? What does it mean in practice? Well, we've got two federal court judges, including the Chief Justice, expressing doubt about whether it is a compendious obligation, but without expressly ruling that it is. We've got Beach, based on precedent, firmly confirming that the efficient, honest, and fair obligation is a compendious concept, and I think he gave some quite compelling reasons. We've got Justices Jackson and now Justice Mashinsky declining to express a view, but declaring that a breach had occurred nonetheless. And I guess you might say, well, what does it matter? I think it mainly matters for insurers for a couple of reasons. Firstly, claims handling is now a financial service. So there will be an identifiable financial service in claims handling. So we have to act efficiently, honestly, and fairly in providing that financial service of claims handling. We have seen this tendency to elevate fairness above the other elements of the concept, particularly in circumstances where the court thinks that there's been some unfair advantage taken, some information asymmetry, some power imbalance, some elevating of interests as it's been expressed. But I guess the interesting question is, given that insurers already have the obligation to act with utmost good faith, and that would normally require an insurer to act fairly and reasonably in assessing a claim, what does the efficient, honest, and fair obligation add to that, even if we do elevate the fairness component? I mean, I think certainly what you will probably see is that if ASIC alleges a breach of good faith, it will tack on efficient, honest, and fair, because we've seen that track record. Whenever there's another breach, they tack that one on. But the interesting thing is, when would it stand alone? When would it stand alone in a claims handling concept? Maybe if there was some systemic failure, like there was, for example, in the Asgard case with the coding error, or maybe if there was some really egregious breach of commercial morality or community expectations. But as we can see, I think we need to watch this space, and those octopus tentacles could start reaching out. And I'll now hand over to Laina to explore that a bit further.
Thank you, Pam. Can you hear me?
Yes.
Okay. So the point is that many times the cases have not actually opined upon how it is the efficient, honest, and fairness obligations have been breached, because the ruling from ASIC RG 104 actually makes it very clear that the EHF obligation is both a standalone obligation and a general obligation that underlies all other obligations. So we will be seeing, as time goes on, ASIC will always tag it on into their statement of claim when they're also alleging unconscionable conduct or any of the other general or core obligations that financial services licensees are under. But of course, it is still possible to breach the obligation even if the FSL or the representative is complying with all of its other specified obligations. Now, in relation to the Westpac case, I think we have to bear in mind that ASIC had brought their case against Westpac administration on the basis that Westpac had been giving personal advice. And so when it got up even into the High Court, it was always accepted at the full federal court level and at the High Court level that if ASIC could make out their case that Westpac had been giving personal advice, then it followed, or Westpac accepted, that it had also then breached this EHF obligation. So that's why we have in the full federal court and in the High Court just a discussion about whether personal advice had been given by Westpac. And because it was accepted, as I said before, that if personal advice had been given, then it followed that the EHF obligation had also been breached. And so that's why Alsop and Brian J said that they couldn't opine, obviously make a ruling on whether it was a compendious concept or not, because it just had not been argued. But this whole concept of whether it is a compendious concept, as Pam says, arose from what Justice Young said in Story back in 1988. And he said, and I've had a lot of difficulty understanding this, and I think it might be worthwhile just saying exactly what it is Young had said. He says, basically, it's a compendious concept, which means that you have to go about your duties having regard to the dictates of honesty, fairness, and efficiency. I don't know quite what that means. So he says you have to be efficient having regard to the dictates of honesty and fairness. You have to be honest having regard to the dictates of efficiency and fairness, and you have to be fair having regard to the dictates of efficiency and honesty. And honestly, I don't know what that means. But if we go back to statutory construction, we do know that you always have to construe words in context. So I guess this is what they're trying to say, that we have to look at the words as they sit together. However, I don't see why it can't be standalone concepts either, like Justice Alsop say and Justice Bryan says, because why can't you comply with all three obligations in the one hit? And as Pam says, it connotes this requirement of competence, and I won't go any more into that. And when they talk about efficiency, the cases haven't actually talked about efficiency in terms of time, but I think it's relevant if you're dealing with claims handling. And sometimes it takes a very long time for an insurer to come back and grant and tell the insured as to whether or not claims are will be granted indemnity or not. And I think that if too much time is taken in order to provide the insured with a ruling as to whether indemnity has been granted or not, then I think that it could very well contravene their obligations to act efficiently. But of course, there have not been any cases at all that have opined upon this. That when the cases have talked about efficiency, they've just talked about being adequate in performance, producing the desired effect, is capable, competent, and adequate. And I don't understand why they haven't. Perhaps the context hasn't arisen when they've had to talk about efficiency in terms of timeliness of advice or timeliness of the service. And as Pam says, you don't have to be dishonest at all, but Justice Alsop, who loves talking about commercial morality, I mean, whenever he talks about unconscionable conduct, he likes to imbue this sense of commercial morality, but I don't quite understand what that means either, because a company, has to act through the individuals, and really, you're really talking about whether the individuals themselves are acting, or the officers, are acting in an ethical manner, because it's the conduct of the officers and directors that are actually imputed into the company. And so when he talks about commercial morality, that is quite difficult as well to understand what he actually means, because he doesn't actually say. He talks about social norms and commercial morality, but is that standard across the field? Like, what is moral for someone may not be moral to another person. And so it's, again, very difficult to understand exactly what they mean when they say that. But they've made it very clear that you do not have to be dishonest in order to have acted unfairly. And again, they import this concept of being ethically sound. Now, Pam's already talked about Camelot. And as I said earlier when we started, the cases that have excited the interest of ASIC have been when the financial services licensee acts in a way to prefer its own interests. So in the Westpac case, they went on this campaign because they wanted to increase their funds under management. And by embarking on this course of conduct and calling up every single one of their clients, they managed to increase their funds under management by $650 million. And they did this in circumstances where they said that they were not providing personal advice, but they kept just telling these clients that they were calling up that if they rolled all of their superannuation accounts into the one fund, into their fund, the BT Funds Management Fund, then they would save on fees, which is undoubtedly true, and that somehow it implied that it would then improve their financial performance. But they did this without bothering to find out whether any of the other superannuation funds that the clients were a member of actually charged smaller fees, or how those funds were performing in terms of their investment. And they didn't do any of this because the whole purpose, and they didn't reveal this to the clients, is because they wanted to increase their funds under management. And in that way, they were preferring their own interests over the interests, potentially over the interests of the clients. So it doesn't necessarily mean that in practice that the client's interests have to actually have been subverted to the interests of the financial services licensee, because it could well be that it was a win-win situation, and in many of the circumstances the clients might very well have been better off because their funds had all been rolled into the one superannuation fund. But that's not the test. The test is that the financial services licensee has to go through the process of making sure that they comply with their obligations in relation to, in the context of the Westpac case, providing personal advice. So when you do that, you have to make sure you go through the steps that you have to go through. And in the Westpac case, they hadn't done that. And for that reason, they were found to have not complied with their obligations in providing personal advice. Then we thought I might talk about, there are some other cases here. And at the end of the day, when we are deciding, or when ASIC or the court has to determine whether or not the EHF standard has been breached, all contraventions must be considered in the context of the operation of the business as a whole. So you don't just focus in on the behavior of one representative, etc. You have to look at the whole business, and you have to look at, see, what were the processes that were in place, because that's one of the obligations, core obligations, that the financial services licensee has to have systems in place to ensure that it complies with its core and general obligations. Now, so it's clear now that while it's unclear as to exactly what is involved in behaving efficiently, honestly, and fairly, we do know that if you breach any of your other core obligations or general obligations, then it will pretty much follow that you're also going to be in contravention of your efficient, honest, and fair obligations. And that's what happened in the case of ASIC and RI Advice Group, where in that case, RI Advice Group used to be a wholly owned subsidiary of ANZ Bank, and they've since divested themselves of that business. But back in 2013, I think, the RI Advice Group had targeted a particular financial advisor, a Mr. Doyle, who was a fantastic salesman. He managed to write so much business, even though he wasn't very good with his paperwork. He couldn't pass the financial competency test within the time period that they're supposed to pass it. It took him 18 months to pass the test. He couldn't get on top of his paperwork. He sold clients, managed structured products that were just not in the best interest of their clients. One of those products was on the approved list of products that the financial services licensee could sell, but another product wasn't. And it took the RI Group, ANZ Bank, many, many years to finally terminate the services of Mr. Doyle. And in that time period, Mr. Doyle wrote, I don't know, $85 million worth of business. He wrote so much business, he didn't have the paperwork, but it was clear that the financial services licensee was earning a lot of commission from this practice. And they had many reasons as to why it took them so long to suspend the financial services licensee, because it said he had so many clients that it would cause a lot of hardship to the clients. But in the meantime, while they were letting him loose and letting him write all this business, and they were hiring people, to a particular lady to carry out all his paperwork, to do all his paperwork, that was actually a black mark against the financial services licensee, because she essentially did all the paperwork, and so the representative could not demonstrate at all that he was able to comply with his obligations in relation to the provision of statements of advice. And so that is quite, I think that's a good, as a result, he was found to have not complied with his obligations to provide advice that was in the best interest of the client. And those are the obligations around 961. And because he was found to have clearly, not he, well, he and the financial services licensee FSL, RI Advice Group were found to have contravened those sections in the Corporations Act, the judge said that it followed that the FSL and the representative had both also breached their obligations in relation to efficiency, honesty, and fairness. And so I just wanted to talk about the AMP case. The ASIC has commenced proceedings against AMP. And I know we all heard a lot about the practices of AMP during the Hayne Royal Commission, in which AMP was still deducting the premiums for life insurance after their members had already died. But it's a little bit more than that. When we look at the pleadings and the statement of the concise statement that ASIC has kindly posted onto their website, what AMP was really doing was, under their general group, they had two superannuation companies. They had the life insurer, who was administering the two superannuation trustee companies, but it was also acting as the insurer of these life insurance policies. They had a financial planning arm, again under the umbrella of the AMP group, who was providing advice to the members as to what life insurance policy that they should be obtaining. And they were paying itself the fee for the provision of this financial advice. It was writing the life insurance policies, and it was also paying themselves after they had been told that these members had passed away, the continuing to pay themselves the premiums for those life insurance policies after the members had passed on, and also they were continuing to pay themselves the fee for the financial advice after the member had passed on. And so ASIC has brought proceedings against the AMP group of companies. There's 5 companies that have been sued. There's the 2 AMP superannuation entities, the trustee company, the life insurer. The trustee company for the 2 superannuation companies actually also not only behaves as the trustee company for those 2 superannuation funds, but it's also the insurer. The financial planning arm has also been sued, and it has been sued for unconscionable conduct and a whole range of other causes of action. And tacked onto that is also the fact that the 912A obligation to act efficiently, honestly, and fairly. And I think that it's quite clear, it seems to me quite clear anyway, based upon the cases that we have looked at, that ASIC will be, that the AMP group, those 4 entities anyway, will be found to have behaved not only unconscionably, but it will also be found to have breached its obligation to act honestly, fairly, and efficiently. And so at the end of the day, I don't know in how many circumstances it will be that ASIC will commence proceedings against a financial services licensee solely on the basis of its failure to act honestly, fairly, efficiently, honestly, and fairly, without also tacking on all of these other obligations. Because as the title of this talk goes, it really is a wrap-up provision. It really sweeps under its umbrella, sweeps under the octopus's tentacles, all of the obligations of the financial services licensee, and overarching all of that is then this obligation to act efficiently, honestly, and fairly. And it seems to me that the one thing that the one thing that the Corporations Act, I think, is seeking to prevent is for insurers or brokers, etc., all financial services licensees, to act in the best interest of their client, not in the best interest of themselves. And so that's very clear, and that's why in all of the cases that we have seen, we've always seen some kind of element of the sale of a product or the provision of advice, but generally the sale of a product to customers, to clients of these financial services licensees that just are not in the best interest of the clients. And that's what I think, that's what insurers and brokers have to be really careful about, that when you are selling a product to your potential insured, you have to make sure that the product that you are selling actually is suitable to the needs of the insured. There's not much point in you, if the insured tells you, we do business A, B, and C. Our business involves a range of activities A, B, and C, and the insurer just provides the broker with a policy that perhaps only covers the activity A, but it doesn't cover activities B and C. But it's been made very clear to the insurer that the business that this insured engages in covers activities A, B, and C. And the policy is just handed back to the broker and say, here you go. In those circumstances, is that policy really in the best interest of the client? And has the insurer complied with its obligation to act efficiently, honestly, and fairly when it just quietly hands back a policy of insurance that doesn't cover potentially two of the activities that the insured engages in? And I think that is the risky area for insurers, because I know, having done so much insurance work over the years, that insurers are very mindful to minimize the risk that they wish to be exposed to, and to only cover certain types of risk in their various insurance policies, and that what may be normal for them, and it's not necessarily, well, generally it's not in the best interest of the insured. And these obligations under the Corporations Act make it very clear that if there is a contest, when you are providing personal advice, for example, if there's a contest between the interests of the insured and the interests of the financial services licensee, then the obligation is on the FSL to always prefer the interests of the client over the interests of itself. And so in that way, I think the obligation on insurers and brokers has really been elevated. And the fact is that the efficiently, honestly, and fairness obligation brings with it a civil penalty, and which is so high that if it was, it's a 2.5 million penalty units, and each penalty unit is currently at $222 per penalty unit. So there's a maximum possible penalty of $555 million. So I think that and that penalty has been in place since 2019. And I think that sends a very clear message to the industry that ASIC wants the insurers and the brokers to really pull up their socks and to start writing policies that are more suitable to the needs of the insureds. So I think I would like to leave it there, and then we can take some questions.
Thanks so much to both Laina and Chan. We've got time for some questions. We've had some come through, so I'll just press straight on with those. One of the questions, a couple that are similar in respect of how this interplays with AFCA, and whether this same approach taken by the courts would be applied in the AFCA fairness considerations. Maybe for you, Pam.
Sure. Well, I think AFCA was very excited when the full federal court judgment in Westpac Securities was handed down, because that emphasis, I think, by both Chief Justice Alsup and Justice Justice O'Brien on fairness in particular, really resonates with the way AFCA sees its jurisdiction, because AFCA, its test when it reviews a complaint is whether the outcome is fair in all the circumstances. So it fairly, by its legislation and by its governing rules, AFCA has to consider the fairness question. And it's different from a court in that regard, because it's not looking at what's lawful, it's looking at what's fair in all the circumstances. So it does have a different test to apply. But nevertheless, AFCA takes heart from the fact that you do have the Haine Royal Commission calling out fairness. You do have judges in the full federal court calling out fairness. And so I think you can expect to see AFCA taking a steer from that full federal court judgment when it applies its own fairness jurisdiction. And as you know, because fairness is so subjective, AFCA has tried to, if you like, create a roadmap of what are some of the objective indicia of fairness, because often you might not be able to define fairness, but when it's not there. You can almost define it by what it's not, and so that imbalance of power, that information asymmetry, that taking unfair advantage, that being secretive and not transparent, not making full disclosure, all those kinds of things are in this roadmap of the tests that AFCA looks at when they try to decide whether something was fair in all the circumstances. So I think that is something that we will continue to see AFCA do, that they will not just focus on what was legal, they will focus on what was fair, and they will take their steer from some of these judicial pronouncements, even if they're only obiter.
Wonderful. Laina, you talked about the seriousness of the penalties that may be imposed, and then you gave us some scary numbers there at the end. And Pam, you mentioned that the Westpac decision was 10 and a bit million, I think, which was not referable to the efficiently, honestly, and fairly breaches because there wasn't, I suppose, a civil penalty attached to it. Any comment on what it might have been had it been a civil penalty at the time? Would it be different, that penalty? Would it be bigger?
Oh, I think it would definitely be bigger. And I think that's the scary thing. I'd be happy to defer to Laina on this, but if there's a $10.5 million penalty for giving unauthorized personal advice, and on top of that, there had been a penalty for what the judges variously described as sharp practice, calculated practice. The language there was very disproving, shall we say. You can imagine they would have been seeking penalties then over and above just for that discrete breach itself, had it been available to them at the time. Laina, what are your thoughts?
No, I think so. I mean, I thought 10.5 million wasn't really that much, considering, they brought into an extra $650 million in funds as a result of this process. So I don't know. 30, 40.
But it would have been more. It could have been more if they had been able to apply a fine for the efficient, honest, and fair breaches.
No, I understand that. I'm saying that if they had also been able to levy a civil penalty for this EHF obligation, then I don't know, maybe they would have asked for 30, 40, $50 million. I don't see it as going to 100. I don't know, but I mean, there hasn't been any guidance yet, but 30 to 50,000. Sorry.
One last quick question then, and perhaps more of an observation from you both. about how what we've talked about, the EHF obligations, ties in with the product design and distribution obligations, and how that, whether there's an additional protection, I suppose, with respect to some of those target market determination obligations that will come in, will come in October as well, and how you see the two interplaying.
I think that the EHF obligation appears to behave like a bit of like a filling in the gaps. It's like putting icing over all of the obligations and filling in any holes. And then as a result, everything is just wrapped up and everyone's just to behave nicely and fairly. And it really enhances the misleading or deceptive conduct obligations and the unconscionable conduct obligations. It really covers off, you know, conduct where an insurer or a broker may have been guilty of misleading or deceptive conduct because they have kept silent, you know, and it's the EHF obligation will obviously cover the same kind of scenario. So it seems to be like a cover-all provision to make sure that if anything else is not caught by any of the other obligations, you can then come in and get it with your EHF obligation.
But it did occur to me when you were speaking, Laina, about the mis-selling risk, that in some ways your design and distribution obligations, if you have a good solid compliance regime around them, may help you to avoid some of that mis-selling. So it might actually act as a you know, a risk mitigant, if you could put it that way. Mind you, if you breach the design and distribution obligations, then you're right, you're just going to get slammed with efficient, honest, and fair as well, and you know, risk double penalties, I suppose. But I think if you comply with them, they could be a risk mitigant.
That's right. We have to be open. You can't behave in a secretive way.
That's right. That's right. Excellent. Well, thank you both, ladies. We really don't have any time for any more questions, so I apologise. Just a reminder that you can get a copy of the webinar. You will get it emailed to you, and you can get it in the library later. I'm sure virtually everybody is thanking me, joining me in thanking you both for your time today. We really do appreciate it, and we know how much effort goes into it, and it was a really engaging and insightful presentation. So thank you both. A couple of housekeeping matters for AILA. There's upcoming webinars left, right, and centre. Just keep an eye on your invitations in your inbox and also on our website. And just a reminder to check out the website for the benefits of membership. So thank you all. Stay safe and good afternoon.